Do I really need to read the entire contract? My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. And today we're going to talk about a pretty common question I get from business owners and non-business owners alike. You've been handed a big long contract, you're looking at the pages, and your call is to me to say, Andrew, do I really need to read the entire contract? Unfortunately, as a lawyer, you know what I'm probably going to say, and that is, yes, you need to read the entire contract. But to try to help you along today, we're going to look at 9 different terms, 9 different types of provisions you're going to see in your contract that you want to make sure you go through and you understand. The first provision is actually called the term. And the term is, how long does your contract last? Is it a 1-year contract? Is it a multi-year contract? Does it automatically get renewed? We've talked before about automatic renewal clauses. Does somebody have to send you a notice if they intend to renew it? Or do they have to send you a notice if they intend to cancel it? So the first thing when you're looking at a contract is understand how long that contract lasts. What is that time period? The second provision you need to look at, which you're going to be very interested in any contract, is the payment terms. Whether you're the one paying the money or receiving the money, it's very important that everyone understands how the money is moving between the two parties or more parties in any kind of contract. How much are you going to get paid, or how much do you have to pay? What you think is going to be a straightforward number may not be. If there's other provisions later in the agreement where there's a percentage of sales, or maybe someone's owed commission on something else, we need to look at and understand all of the different payment terms. Third provision we're going to look at is, what are your obligations? And there's probably not going to be your obligations as the name of the provision, but you want to understand what you're obligated to do. Read through the agreement, figure out what you have to do. What are you being paid for, or what are you paying, and what is the other party doing to satisfy their terms under the contract? Fourth thing we want to look at is intellectual property. So this is a fancy legal word for your copyrights and trademarks and your other property that is, it's not like buying a car, it's not your wheel for your car. It's all of the patents and the design that went into that wheel, that went into that car. If you're working in a contract and the two parties are going to be sharing some kind of intellectual property, we want to make sure we understand what that contract says. Who's going to own it at the end of the contract? If somebody's bringing their own intellectual property to the contract, they usually want to make sure that it stays theirs after the contract is over. The next provision to look at is termination. How do we end the contract? So if you have a simple 1-year contract, at the end of the 1 year, you're done. However, in a lot of other contracts, you may have ways that you can terminate the contract early. And if that is the case, what do you have to do to terminate the contract? Is there a notice you have to send? Is there something else that has to happen? So make sure you understand how you can terminate that contract. And if there is no termination clause, then you may want to be concerned about whether or not you want to sign this contract, because that may be that you're stuck in this contract and you're paying money no matter what, because there's no way for you to terminate the contract. The next provisions we look at are liability and indemnification. And these provisions say what happens when something goes wrong. Who is going to be responsible for it? If somebody has an insurance policy, is the insurance policy going to pay for it? And then when we look at the word indemnification, this is another one of those big legal words that people often see and they stop and go, I don't even want to read this provision. I don't understand indemnification. So what it is it says that you're essentially insuring somebody else's obligation. So a subcontractor indemnifying a contractor means the subcontractor will be responsible so that somebody couldn't sue the contractor for the subcontractor's work. The next provision we want to look at are tax issues. So depending upon the nature of the contract, if it's like an independent contractor or if it's an employment contract, we want to know that the tax issues are spelled out in there. Independent contractors do not want to be treated as employees, and companies do not want to treat independent contractors as employees. However, if it's an employee working with a W-2 at the end of the year, we want to make sure that the agreement is clear on what the tax implications are for both parties. And then governing law is another provision we're going to look at. A lot of times people gloss this one over because it's near the end, and it's going to say, in case of a dispute, the laws of blank. So the laws of New York will govern this dispute. If you have 2 people living in New York, exchanging goods, whatever they're doing in New York under the contract, that's perfectly fine. What I often see is one party has gone online and they've downloaded a contract template from somewhere. They've gone to some website and they said, great, this will be fine. And so then they fill it out, they put their information in, they send it to the other party and they sign it and everyone thinks it's good until there's a problem. and you find out that the first party is in New York, the second party is in New Jersey, but the contract has a governing law clause of Texas. There's no reason why a New Yorker and someone from New Jersey should have to then fly to Texas to have a lawsuit or have a dispute. You can easily do it in New York, you can easily do it in New Jersey, or you can fight over which state it should be in. But that governing law provision, it's important to understand where it's placing the jurisdiction so you know what court you have to go to. Because in our example, if that New York party sues the New Jersey defendant, sues the New Jersey party in New York court, the Jersey defendant can say, we have to go to Texas. So we can dismiss this case and good luck figuring out how to file your case in Texas. And then you get to Texas where the Texas judge may say, I don't want anything to do with this. What do I want to do with a New Yorker and someone from New Jersey? I don't want any part of this either. And you're stuck in this weird limbo because you downloaded some random contract from the internet and didn't look at what the governing law provision was. And the final provision that we're going to look at, which has been very important over the last couple of years, is what's called a force majeure clause. The force majeure clause says what happens under the contract if there's some catastrophic event. Now, for years, we've had things in there. We've actually had the word pandemic in a lot of our contracts with force majeure, but nobody thought a pandemic was going to happen. And now here we are, and we have to figure out what does happen. If there's supply chain issues, if there's some problem where you're unable to get the goods you need to ship to the other party, is there a force majeure clause? If so, that clause will say what happens in the event this catastrophic event has happened. Which party has to do what things? Do you still have to make a payment? Does the other party have to pay you? So you want to make sure you're looking at your force majeure clause these days, because especially over the last couple of years, we've learned it can be a very important clause, and we want to make sure we've got all of our bases covered. So as you know from my videos, there's going to be two ways we can do these things. The first way is you could try to do it yourself. Go online, try to download some form, and hope that you're not from New York with a Texas governing law provision, or hope that you don't download a contract without a force majeure clause. But the second way to do it, the smarter way to do it, which you'll probably do, is to work with a professional. Even if you're just consulting with an attorney for an hour, bring them the contract. Pay them for their time to review the contract and make sure you've got the right contract for you and your business. Or if you're not sure if you should sign a contract, same principle applies. Meet with an attorney, talk to them, and figure out whether or not you should be signing this contract. If you have more questions about your contract or some of these provisions, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the first page. Click it and you'll be taken to my personal calendar where we can set up a legal strategy session. It's a 15 or 20 minute phone call to get to know each other and figure out where you are in the process and what are those next steps. Because you don't want to be downloading some random contract from the web and not understand any of these provisions. Because if you sign it and the other party signs it, you may be stuck with it no matter how bad that contract is.